What's up, everybody? We have got the mobile studio here, and we're still bringing you content, even though we're out of the office at this conference. We are at Vid Summit, actually, in Dallas. So if any of you guys are at Vid Summit, let me know that in the comments. And hopefully, we learn some new stuff about better ways to bring you content, better ways to make tiles and stuff. John is here with me. It's our first ever YouTube type conference to try. And in this one, I like that it's focused on making the content better for you and more digestible for you and things like that. And it's also fun. My wife has a friend here that just had twin babies, so she's going to hang out with her. So it's kind of cool, and it worked out, a little mini vacation we're going to have here in Dallas. But some very interesting stuff happening back in Florida, which is the content for this video. It's all about YNW Melly. A lot of things happening. They filed a bunch of motions to suppress. They don't want a bunch of evidence to come in that came in during the first trial. But we are going to focus on a couple of other motions. First, a motion to dismiss that his new lawyer filed, Jamie Benjamin. And two, a motion to recuse the prosecutor prosecuting the case, basically saying, kick these prosecutors out that tried him last time, bring new ones in. And he's got a very interesting reason for that. So stick with us throughout this video if you're interested in this YNW Melly case and the retrial. The first one ended in a hung jury. And that's really interesting because that has given the defense a lot of good arguments to say that there's not as strong of evidence as the state may have once thought, even something the judge may have thought there was strong evidence against him. Obviously, a jury disagreed because they couldn't get him convicted unanimously the first time. So the first thing we're going to bring up here is this motion to dismiss, but hit that like button if you haven't already. And if you're going to stick around through this second time, Melly is going to go to trial. Subscribe to our page if you haven't already, because we're going to continue to bring these updates as they come. But first here, let's get to this motion to dismiss. All right. So it's motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights. So some pretty strong verbiage as to why they think this case should be dismissed. The defendant was tried in the above style cause April 10th, 2023 to July 22nd. The results at trial were a hung jury. The lead investigator in this case is Detective Mark Moretti of the Miramar Police Department. And if you remember this detective, this was one that cross-examination was long and it was difficult and there were mistakes made and things that he did that he was somewhat impeached, but not nearly as much as we can expect in trial number 2 if we get there. Because he was such a main part of the trial and he was the lead investigator, his credibility is not only germane to the case, but has a direct bearing on the outcome of the case. The jury's estimate of the truthfulness and reliability of a given witness may well be determinative of guilt or innocence. And it is up to such subtle factors as the possible interest of the witness in testifying falsely that a defendant's life or liberty may depend. And this is important because what they're doing right now is they're kind of setting the stage of what the burden is and why it's so important that witnesses are credible. And if information comes to light that makes a witness less credible, the jury has a right to know that. And they have a right to throw out his testimony and say, we don't believe it. Even though it's here in front of us, we don't believe it. We don't trust it. We're not going to consider it. In NAPU, I don't know how to say that. The court cited a New York Court of Appeals, People versus Savides. It is of no consequence that the falsehood bore upon the witness's credibility rather than directly upon the defendant's guilt. Giglio and Brady, we know, are when you have exculpatory evidence, the state has to turn it over. And here they cite Giglio and Brady saying information within the state's possession that would have impeached the credibility of Detective Moretti, known to the state, should have been presented to the defendant prior to trial. Unfortunately, that did not occur. In fact, the opposite occurred. So we're getting to the point now of what they think this Brady and Giglio evidence is as it connects to Detective Moretti. For the defendant to establish a Brady violation, the defendant must show, one, the evidence was favorable to the defendant, either because it was exculpatory or because it was impeaching. So when we think about exculpatory evidence, it usually goes to prove the defendant's innocence, but it can also go to impeach a witness and therefore make the credibility lack in such a way that the jury cannot find the defendant guilty, and therefore he still ends up winning the case. My mic just went out. So I'm trying to find the settings and make sure it's back up. Okay, sorry, my mic went out. And that's probably going to happen because I don't have a mic stand and this thing comes unplugged sometimes. I don't have the XLR connection. We're in the mobile studio, so bear with me. We'll get through it. Usually it alerts me if my mic goes off, so I'll try to pay attention. Although the state has an obligation to provide Brady material, nonetheless, on July 25th, the defense filed a Brady request. So again, the state has to turn this stuff over regardless of if the defense asks for it or not. And that's important in discovery because there's no hiding the ball when it comes to this exculpatory or impeachment evidence that they have to turn over. A defendant's life is on the line, liberty's on the line. And listen, the state is supposed to be looking for justice. So we shouldn't have to worry about them hiding information, yet sometimes that's exactly what happens. So the defense, basically in an abundance of caution, is like, do you guys have any Brady material? We know you're supposed to give it to us, but just in case you haven't yet, give it to us now. The defense has been requesting of Assistant State Attorney Christine Bradley, who was the main ASA in the case, if you remember the trial, information in regards to the investigation as to what occurred when the phone of Jamie King, the defendant's mother, was seized. The responses have been simply, there are certain named witnesses under investigation. On August 23rd, 2023, the defense served another Brady request. This was for information regarding the investigation of Detective Moretti for the use of excessive force against Jamie King. And we heard how Jamie King, the threats that were made to a lot of witnesses in this case, not just Jamie King, but we're focusing on her here. On August 30th, 2023, Ms. Bradley responded that Internal Affairs has it in Miramar. In fact, on the date of this court's last calendar call, September 22nd, 2023, outside the courtroom, Mr. Edelstein, who you remember from the first case, asked the prosecutor what was going on as to any internal investigation with Detective Moretti based upon seizing Ms. King's phone. In essence, Ms. Bradley stated that the investigation was closed and no wrongdoing was determined. Ms. Bradley was also asked what the best procedure would be in order to take the deposition of Assistant State Attorney Michelle Boutros, who was present when the phone was seized. Ms. Bradley responded that the officer required a subpoena and then interjected that, however, Michelle Boutros was very ill and at home, certainly giving the impression that she was too ill and infirm to be part of this matter. Ms. Bradley was also asked if we can get Ms. Boutros' sworn statement. Ms. Bradley responded she doesn't have that and have the file. Okay, so dodging it, trying to set up roadblocks, obviously not forthcoming from Ms. Bradley. Subsequent to that conversation, counsel for the defense learned that, in fact, Ms. Boutros has been working and is available to go into the state attorney's office. The defense has set Ms. Boutros for deposition on Friday, September 29th. Counsel for the defense has also learned that that day, again, after the conversation outside the courtroom, Ms. Bradley, in contravention to statements made to the defense, was actually quite involved in the matter, including having conversations with the head state attorney and the assistant to the chief in regards to Detective Moretti. So Bradley was actually involved and knew what was going on with Moretti, and was involved in the file, yet said not her file. That's concerning. Later that day, Mr. Edelstein, by letter, confronted Ms. Bradley with her less than candor. In response, the attached notice pursuant to Rule 3.220B4 was filed. Counsel for the defendant, as noted above, expects to be taking the deposition of Assistant State Attorney Michelle Boutros, who was present during the altercation, and enlighten not only the defense, but ultimately the court on exactly what transpired, as opposed to Ms. Bradley's secondhand hearsay rendition. Regardless, the information provided by Ms. Bradley indicates that Detective Moretti executed the search warrant outside of his jurisdiction and therefore illegally. It would have allowed the defense to question him as to whether he committed a robbery or a battery on Jamie King when he unlawfully took her phone. It would have shown that Detective Moretti was willing to lie as to who served the search warrant, an official court order. And it would have shown that Detective Moretti was willing to conspire with Deputy Gorel to obstruct justice and to create false filings. This was impeachment evidence favorable to the defendant. The first prong of Brady is met. I mean, that's wild. If this detective is just lying and willing to lie, and again, are they bad guys? I guess the answer is yes, right? And if any normal person did this, they'd be convicted of a crime. So the badge does protect them from certain wrongdoing, which is horrible, and they should be held to a higher standard, not a lower standard, number one. Number two, I do think that they do this because they think they have the bad guy and they think it's necessary. It's a necessary evil. It's a gray area. That's what I think law enforcement thinks, and they're dead wrong about that. And their feet need to be held to the fire. And if a guilty man goes innocent because of it, that should teach them a lesson that they are putting a guilty person back on the streets because they didn't follow the rules. And that's something they have to do. It's not a criminal defense attorney's fault. It's not a judge's fault. It's not the system's fault. It's the law enforcement officer that breaks the rules' fault. Rather than presenting this to the defense so that the defense could have used it during the first trial, the state withheld this information. That's horrible. He's a key witness. We know, we watched the trial. We have the benefit of that. So in order to destroy his credibility, that would have been huge in the first trial. In fact, it is believed that the highest levels of the state attorney's office made determinations to not provide it to the defense. And secondly, not to pursue the internal affairs investigation. It's like telling on yourself, right? This was the institutional policy of the state attorney's office, not just one prosecutor. So this goes way up. This isn't just Christine Bradley. This goes way up in the entire office that prosecuted Melly, according to the defense. This evidence was suppressed by the state. The second prong of Brady is met. And again, they don't even have to say willfully, because even if it was inadvertently, second prong is still met. The unfortunate stark reality is that the state intentionally withheld this information that would impeach Detective Moretti in order to gain a tactical advantage and violate Mr. Demon's due process rights as guaranteed by the 14th Amendment to the United States Constitution and the parallel provisions in the Florida Constitution. Because this withholding of evidence was not only institutional but deliberate, prosecutorial misconduct, double jeopardy principles apply, and the case must be dismissed. So this is where it's a bit of a stretch and a bit of a conversation. This could have caused a mistrial and a retrial if they found out about this during trial. Or they could have at least impeached him when he was on the stand or brought him back to impeach him again later. But now that a hung jury has already happened, a jury was impaneled and they came back with no verdict and it counts as a mistrial, they're going to argue that this whole process is so unfair and therefore to try him again would be prosecutorial misconduct and would be double jeopardy, because if they would have had this in the first trial, it would have been not guilty. They didn't have it. They had to go through all that. They shouldn't be able to try him again because they're withholding important evidence. Usually that's not going to win on double jeopardy grounds. As noted above, this was a hung jury. Normally, the remedy of Brady or Giglio violation is a new trial. However, the remedy for prosecutorial and government misconduct is dismissal. And he could be right about that. If the prosecutorial misconduct is so bad, we've had situations like this come up with FBI and law enforcement and prosecutors that judges have dismissed cases. So not necessarily on double jeopardy grounds, but on prosecutorial misconduct, dismissal of the case is actually something a judge could find. I don't know that they're going to find it went quite that far in this case, but it's absolutely a remedy that the defense can ask for and may be entitled to depending on how bad the judge thinks this really is. As noted above, this was I already read that. As the United States Supreme Court noted in Pyle, petitioner's papers are inexpertly drawn, but they do set forth allegations that his imprisonment resulted from perjured testimony, knowingly used by the state authorities to obtain his conviction, and from the deliberate suppression by those same authorities of evidence favorable to him. These allegations sufficiently charge a deprivation of rights guaranteed by the federal constitution, and if proven, would entitle petitioner to release from present custody. So now they're saying that because they didn't have this information about Detective Moretti, he perjured himself when talking about how he got the information. There's fruit of the poisonous tree that they're going to ask to be suppressed based on this unlawful search and seizure, based on this search warrant issue, based on the crimes they say are committed by Detective Moretti, including perjury. And therefore, without that fruit of the poisonous tree that was used against Jamel Demons in the first trial, it would have been not guilty. This is an injustice, a miscarriage of justice. We've got to dismiss these charges now. I got to say, they have way too much to argue here. A defense should not have this much when the prosecutor holds all the cards and makes all the decisions. Here, certainly withholding of favorable evidence, whether illegal criminal activity or unethical behavior, requires a dismissal. Either or, it's going to require a dismissal, the defense argues. As the court noted in Cruz, in analyzing the issue, the courts must focus on whether the favorable evidence could reasonably be taken to put the whole case in such a different light as to undermine the confidence of the verdict. And that's basically what we're asking in this case. Is what's going on here compromising the verdict, which was a hung jury? So no one knows the proverbial what if. However, given the hung jury and the inability to cross-examine the lead detective in this case as to his role and desire to skirt or break the law in furtherance of the investigation, it would have changed the outcome. So they don't know if it would have changed the outcome, but they think it would have, and that's what they're arguing based on what they know now. And they basically argue that it obviously wasn't a strong enough case to get a conviction in the first place. As the court noted in Shepard, moreover, prosecutorial misconduct can constitute fundamental error. Prosecutorial misconduct may so infect the trial with the unfairness as to make the resulting conviction a denial of due process. So what I will say is I do think they have enough to argue if he would have gotten convicted, this would have been an appellate issue that would have granted him a new trial, in my opinion. But because it was a mistrial, I think we need to have a new trial. I don't think necessarily it's going to rise to the level of dismissing the charges. But if it did, I wouldn't disagree with the judge. The state has been sitting on this information since October 12, 2022. It allowed one trial to go by while concealing this evidence. Obviously, they were planning on allowing another trial to go by without revealing this information. Only after the defense started to uncover what happened on that date between Detective Moretti, BSO deputies, and Jamie King in the presence of Assistant State Attorney Michelle Boutros, was the state forced to reveal what it had been hiding. The defense has shown through his motion that the state willfully withheld impeaching evidence as to Detective Moretti in order to gain a tactical advantage. However, it is also believed that the state has basically shelved an internal affairs investigation and possible criminal investigation into Detective Moretti as to this matter, so that it could not be used against Detective Moretti at trial. So they're basically shelving it. Maybe we'll deal with it later when he's not such an important witness in a high-profile trial. That's what the defense is arguing. In essence, the state has intentionally done whatever it could to sanitize Detective Moretti's actions so they would not be fodder for cross-examination during trial. Although the defense has only uncovered the tip of the iceberg in this matter, this tip is sufficient for the court to determine the defendant's due process rights guaranteed by the United States Constitution, 14th Amendment, and the parallel ones in Florida, that his fundamental rights have been violated and the only remedy is dismissal. So this is so bad, Judge, you need to dismiss this case. Based on the due process provision in Article 1, Section 9 of the Florida Constitution, we agree with Hohensee and Isaacson that the governmental misconduct which violates the constitutional due process of the defendant, regardless of the defendant's predisposition, requires dismissal of criminal charges. The third prong of Brady has been met. And that's filed by the new defense counsel, Jamie Benjamin's firm. Okay, but wait, there's more. Now, based on additional information filed a few days later here. When was this filed? So this was filed on September 29th, which, if you remember from the last motion, is the same day they were going to depose the prosecutor, Michelle Boutros, who was allegedly there, according to Detective Moretti, allegedly there during this search warrant execution on Jamie King, Jamel Demons' mom. So let's see what this one's about. Now, we need to recuse the state attorney's office of the entire 17th Judicial Circuit and for Broward County. It's a big deal. All right, defendant is currently charged 2 counts first-degree murder. The defendant has previously gone through trial in this matter, ended in hung jury, scheduled to start trial again on October 9th. Imagine having to get totally new prosecutors, then creating timing issues, right? Because the defendant has a right to have a retrial within this, I think it's 90-day period, which is when they set the trial. So if a new prosecutor has to come in, they either have 6 days to prep for this trial now because it's October 3rd when I'm recording this, or are they going to violate the timing rules of when they have to retry a case after a hung jury? Very interesting stuff here, and we're going to have to keep an ear and eye on it. In the past week, the defense has learned of blatant Brady violations, i.e. the lead detective in the case solicited another officer. So now they're accusing Moretti of soliciting another officer, a BSO deputy, Broward County Sheriff's Office deputy, to lie for him and state that the deputy was present when Detective Moretti served a search warrant on Miss King. Ooh, it's just getting worse for Detective Moretti. There's no dispute that the deputy was not present. So that deputy was not there, regardless of what Mr. Moretti wanted them to say. Very shortly after the deposition, Ms. Boutros let her supervisors know of Detective Moretti's willingness to fabricate testimony. She also informed those supervisors that she would never work with Detective Moretti on a case. This is Michelle Boutros, who is a state attorney right there in Broward County, and she will never work with this detective who was willing to lie, cheat, and steal, literally taking evidence from Jamie King with an unlawful search warrant, according to the defense here. That says something. And wow, if he takes the stand in trial too, is he going to get destroyed on cross-examination? Isn't it true that state attorneys from this office sitting right here refuse to work with you? And why is it? Because you're willing to lie and tell other officers to lie. Isn't that true? That would be a really fun cross-examination for a defense attorney. Since October of 2022, prior to any trial commencing, Assistant State Attorney Christine Bradley, who's assigned to this case, knew of this Brady material. So now he's impugning Christine Bradley. On September 29th, counsel for the defense was able to depose Michelle Boutros. Undersigned is still trying to unwind exactly what transpired within the state attorney's office, but it's safe to say on what was divulged at this deposition, which happened this same day, I believe, that this motion was filed, that should Detective Moretti be called as a witness in this case, that Ms. Boutros certainly would be called by the defense to testify as to Detective Moretti's credibility and the fact that, I'm adding this, she would never work with him on a case again. From the various Brady responses filed by the state over the last week, it is obvious that Ms. Bradley had her own conversations with Detective Moretti as to soliciting a BSO deputy to lie. So Bradley also knew about it. Oof, doesn't look good for her. Being that Detective Moretti's credibility may be one of the biggest issues at trial, Ms. Bradley also now made herself a witness. What does she know? What does she think of him? Why is she willing to work with him if Ms. Boutros is not? Further, as to the defendant's motion to suppress evidence, Detective Moretti's credibility is automatically at issue since he's signed the affidavits in this case. Therefore, again, certainly Ms. Boutros and possibly Ms. Brady would be witnesses. That is never a good thing. We always talk about our lawyers becoming witnesses, not a good thing. As to the motion to dismiss for government and prosecutorial misconduct in violation of defendant's due process rights, which we just read, it has become clear that decisions on providing the defense with this unmistakable Brady violation or Brady material, which I 100% agree with them, it is Brady, reached the highest realm of the state attorney's office. Ms. Boutros testified that Mr. Pryor, who is the state attorney, Ms. Falk, and Ms. Killoran, over the approximately last year, have been involved in this matter on several occasions. It doesn't look good. Therefore, at the motion to dismiss stage at this time, defense knows that the state attorney, or Assistant State Attorney Michelle Boutros, Assistant State Attorney Christine Bradley, Assistant State Attorney Killoran, Falk, Zacher, Silversheen, and State Attorney Harold Pryor will be called as witnesses. Yikes. To call the state attorney as a witness about how bad this investigation and prosecution has been. Because we know that was already the theme during the first trial. We have the benefit of seeing how it all came out. We listened to the opening statement, closing statement, how horrible the investigation was, how they screwed this up. They didn't test that. They didn't do this right. They had to bring somebody else in who said this is one of the worst investigations they've ever seen. Now, that is interesting that they already did that once and it didn't work as far as a not guilty verdict went. It's good enough for a hung jury, not good enough for a not guilty verdict. So what will the judge be thinking weighing all these options? As referenced above, these are the state attorney witnesses that are known and definite at this time. However, we now know that this matter also went before appellate attorneys within the state attorney's office. We don't know their input. We do not know what their role was in the decision not to provide Brady material to the defense. These people also may be added as witnesses. The defense is setting up here. This is so bad. We don't have this information. We're entitled to it. We need it. It's setting up a potential for even on October 9th. There's no way that a fair trial can go. So what do they do then when the timing starts to get broken? Ms. Bradley has made herself a fact witness through probably the most important piece of evidence in the case, that being the credibility of Detective Moretti. Therefore, Ms. Bradley individually is certainly conflicted in representing the state in this matter. So I agree. I think she is conflicted now, but the question is the entire office. Another thing, we've had cases where the judge has thrown out and dismissed charges because the judge found the officer to not be credible. And what's interesting about that is some people will say, well, let the jury decide. Problem is the jury usually thinks officers are credible, especially in a lifetime past. Officers show up, they're usually taken as more credible than any other lay witness. Problem is, if the court categorically finds, as a matter of law, basically, that this guy is not credible and should not be able to testify under oath because his oath means nothing to him and he's willing to lie, and we know he's willing to lie and fabricate things, then we can't even put him in front of a jury because God forbid a jury believe him when we all believe they shouldn't believe anything he says. So that's a possibility too. However, given the fact that at a minimum, there would be an assistant state attorney, Boutros, as a witness, and there will be conflicting testimony by Assistant State Attorney Bradley, it is untenable for the state to be prosecutors in the case. They're saying two assistant state attorneys from the same office, conflicting testimony, this whole office is disqualified. For one, the fact that assistant state attorney prosecuting the matter while Ms. Bradley is on the witness stand will be from the same judicial circuit as Ms. Bradley. Ms. Bradley being called by the state as a witness would be tantamount to the state attorney's office vouching for Ms. Bradley's credibility, undermining that of assistant state attorney Michelle Boutros. Nothing could destroy a witness credibility more than her own office calling another witness to contradict her. In essence, there are too many witnesses from the 17th Judicial Circuit State Attorney's Office who have testimony germane to the motions to dismiss, suppress, and the trial for this State Attorney's Office to remain as prosecutors in this case. I mean, this stuff is wild. I would be really embarrassed if this was happening to my office, if I'm being completely honest with you. Allowing the State Attorney's Office, and specifically Christine Bradley, to continue as counsel in this cause violates defendants' due process rights guaranteed by both Florida Constitution and the 14th Amendment to the United States Constitution. That is wild, folks. And I will just say this is very unusual that it's this bad. However, the defense pulled no punches in talking about how bad this investigation was, how they locked in on Melly, how they did anything they could to make sure this was the guy. They wanted their 15 seconds of fame. And guess what? This is going to play right into their theme. And when I say play right into their theme, it doesn't mean it's a false narrative. This makes me think that there's more smoke to this fire. Now, does it mean Melly didn't do it? No, I don't know if Melly did it or not, but I am having serious and severe doubts about this investigation, this prosecution, and how this trial is going forward. We're going to see how it plays out at trial, if it goes to trial in less than a week. And there are some major timing issues for the state if this gets delayed. I cannot wait to read these comments and hear what you have to say and hear what you think about this case. So please don't be shy in the comments. Let me know what you think. Let me know what questions you have. And like this video if you're enjoying this content. This to me is wild. And this case has been one to remember. So subscribe to the page if you haven't already. Let me know what you think. I appreciate you all joining me. More coming here from Dallas. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouknow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.